The next matter to come before the court this morning is Sajid Mollagee versus Waheeda Mollagee. Each party will have 15 minutes in which to present their case.
Morning.
Thank you. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind this podium in front here as much as possible. We have read your briefs and are ready to proceed when you are.
Thank you. Good morning. Your Honor, my name is Gary Godfrey. I'm here along with my co-counsel, Douglas Burrow. We are here on behalf of the appellant. This is an interesting case in that it involves something a little bit different than perhaps we normally see in our domestic relations court. It involves some flavor, if you will, of international cases, as we'll get into it. But I think for purposes of this morning, the issue that the court needs to address is to analyze the appeal is did the trial court have what we call subject matter jurisdiction to determine whether, in this case, the appellee, the husband, was entitled to seek legal separation. And we believe that in order for the trial court to have properly analyzed this and for this court to review it, that the trial court was required to determine whether, first of all, the parties had a legal marriage in South Africa. And we believe that that's the starting point. We have cited in our brief a case called Mollagee out of the Supreme Court of Ohio, which basically says that when a court is going to look at a foreign or another state's marriage, you don't determine the validity, and that's the word that the Supreme Court uses, validity. You do not determine the validity of the marriage based upon Ohio law. You determine the marriage based upon the validity of the country in which, in this case, the country in which the marriage was, the Supreme Court calls it solemnized. Where did this marriage take place?
Counsel, I hate to interrupt you this early in your argument, and I actually interested in talking to you about some of the South African law that came up at the trial level, but the
Please
first
do.
question I want to ask you is why or how is this a final appealable order that we even have jurisdiction to look at?
Well, we answered that in our, initially in our motion to, if I may get my notes.
Sure.
We initially answered that question when counsel for the appellate filed their motion to dismiss. And we raised our response, and I'll repeat it here. We believe that this is a final judgment. We believe that it's a final judgment because under 250502B, there are certain orders which are final and which can be appealed. And we believe that in this particular case, the decision of the trial court finding jurisdiction meets the criteria under 250502B. That being number one, there was a substantial right that was involved in a special proceeding, and secondly, that our client was denied what we call a provisional remedy, which precluded our client from pursuing a meaningful remedy in a subsequent appeal. Under 250502, there are 7 categories of judgments that we can look at, and we believe that our client fits within those 2. We believe that it's a special proceeding. The Supreme Court has already said that a divorce, legal separation is a substantial, a special proceeding. Under the Troxel case, the United States Supreme Court has said the right to raise a child is a substantial right. So when you put together the special proceeding and the substantial right under Troxel, we believe we meet that first criteria. Secondly, we believe that under 250502B, that this denial of our motion on subject matter jurisdiction denies our client of a provisional remedy. And a very similar situation occurred in, I believe it's called the Hoogerman, I may not be pronouncing it right, Hoogerman case of the 12th District, which had the same set of facts. And in the Hoogerman case, the 12th District said that a denial of a motion to dismiss jurisdiction is a denial of a provisional remedy. Because if you deny the motion and then you proceed, you really are denied that relief. And then you have to add what Hoogerman talks about, and that is some of the other kind of, maybe call them intrinsic kinds of facts. For example, our client lives in South Africa, and Hoogerman talks about how, when you have foreign litigants, the cost involved, having to litigate this case, go to conclusion, then have to litigate in Court of Appeals when our client, in this case, lives in South Africa. So we believe that the court was correct when on May 18th, it did deny the motion to dismiss.
Provisionally.
Provisionally. I will agree, it says provisionally. I wasn't sure whether you'd want us to talk about it, but I believe that the court was correct.
Thank you.
I think we did meet that requirement. So, any other questions about that?
How about that? Are you retaining time for rebuttal?
3 minutes, please. So, as I said, the issue that I think the court has to focus on is the validity of the marriage in South Africa. And I think that's crucial here, the validity of the marriage in South Africa. When I was getting ready for this oral argument, I was thinking of this movie I saw. I think it's called Cool Hand Luke, if anybody remembers it. And in that movie, the sheriff says to Paul Newman, I think we have a failure to communicate. And I think that's what's going on here, because counsel for the appellee keeps on talking about voidable. When you read their brief, they talk about voidable. That's not the issue. The concept of voidable, void ab initio, whatever that is, does not exist in this case. The issue is validity, and they're different. In this particular case, there were 3 experts. 2 of them dealt with the issue of the question, whether or not these parties who were married, who entered into a Muslim ceremonial marriage, were married under the laws of South Africa. Each one of them, when finally asked the essential question, is this a marriage recognized under South African civil law? Each one said no. Now, I will concede that the appellee's expert attempted to somewhat differentiate and say, well, all of these inroads have been made. So that, for example, a person who engages in this Muslim rite of marriage can have rights of survivorship, etc. But the essential question, when you read the transcript, is that each one of those 2 experts said they are not married under the Marriage Act of South Africa. There is not a valid marriage. Now, what's also interesting in this case is the appellee himself acknowledges they weren't married, had a valid civil marriage. We're not talking about a ceremonial marriage, we're talking about a valid marriage. And the reason why that becomes important is because under Ohio law, you can't have a legal separation unless you have a valid marriage. That's the gateway. The gateway to the court having jurisdiction is a valid civil marriage. Counsel and I both agree on one thing in this case. We didn't agree on a lot, but we agreed on one thing, and that is comedy. The international recognition by courts in one country to another country that if a marriage is valid in country A court in Ohio will accept a marriage in the state of Ohio. But in this particular case, we believe that the evidence supported a finding that there was not a valid marriage. And if you do not have a valid marriage, then the trial court did not have subject matter jurisdiction to terminate that which didn't exist. Remember that in this particular case, the appellee asked for a legal separation. When you read 3501, that's the prerequisite, a valid civil marriage. Now, in this particular case, the appellee in his brief, the appellee at trial, brought in a third witness, Attorney Brown. Attorney Brown is an immigration lawyer, and Attorney Brown said, gee, it looks to me like these parties held themselves out as being married, and he talked about the immigration process. None of that is relevant.
Is a civil marriage ceremony required under the Muslim?
A civil marriage is required to be married under South African law. And if the court will allow me, I will find there's actually a reference, I believe it is page 89 of the transcript, I'm looking at my notes, where that is explained, that there's a difference in South Africa between what you and I would call a ceremonial marriage and a valid civil marriage.
So the requirements are different in each country?
Yes.
Okay.
Yeah. And that's why it's so important for the Ohio court to look at what is the law of South Africa. Don't talk about the law of Ohio. It has no relevance. And that's kind of what the court did, and that's kind of what the appellee does. You know, he says in his brief, for example, that they got health insurance together. They thought of themselves as being married. They, I think, got car insurance. None of that is relevant. In fact, it almost appears that the appellee is resurrecting common law marriage. For those of us who remember common law marriage, if you hold yourself out as married and you do a couple other things, then you're married, well, we abolished that. It almost appears as if counsel for the appellee is kind of going back to that theory. It makes no difference, absolutely none whatsoever, what the parties thought, what the parties did. It all goes back to the crucial question. Were they married in a valid civil marriage in South Africa? Each one of the experts, and the transcript supports this, each one of the experts say no.
Is the issue, were they married in a valid civil marriage? Because everybody agrees that they weren't. This was a religious rights ceremonial marriage. Isn't the issue, and I don't think it's a distinction without a difference, is the ceremonial religious Muslim marriage recognized as a marriage in South African law? Those are two different issues, aren't they?
The answer, I think, is no.
No, they're not two different issues, or no, it's not?
They're
My
not
question was
recognized.
bad, I'm sorry.
I thought it was a great question. The answer is, the way I understand it, that under South African law, there is only one way you can be married, and that is under what they call the Marriage Act. That's it.
Would you agree, and I hate to start it this way because I know your answer is going to be no, I don't agree, but there's an argument that there is a movement under South African law to accept the religious ceremonial marriage as a valid marriage. Now, I know that you distinguished the cases, but isn't there a movement?
Is there a movement? Maybe. But a movement doesn't get us to the answer. Was there a movement in this country to have same-sex marriages? The answer is yes. But until the Supreme Court in Oberfeld said, yes, we have, it was a movement. Thank you. I appreciate your time.
About 2 minutes left.
Your Honors, my name is Jonathan Rich. My colleague, Christopher Reynolds, is here with me. We represent the appellees, lead Sajid, Mullaji. Your Honors, what this case is about is whether or not there's a South African statute that makes these parties' marriage void, or whether or not there is a South African public policy that makes the parties' marriage void. That is the question, and that's the question the trial court answered. The trial court answered that by analyzing the case law and statutes that exist in South Africa. The question is not whether the parties have a civil marriage. Everybody agrees they have a marriage based upon Muslim rights. There's no question about that. But there's nothing foreign about this, and I hate to use that word, but there's really nothing foreign about this concept. We had, and still to some extent have, marriages in Ohio that are not formalized under certain statutes where you have to get a license and you have to be married by someone who's authorized to perform marriages. We still have those common law marriages, and we had them for a very long time. So there are various types of marriages that exist in the world, and specifically there is a Muslim rights marriage that exists and is an active law in South Africa that recognizes those marriages. Now, unless this court can find that this marriage is void, and that is the proper word, it's not about validity. Unless this marriage is void, either under South African law or the state of Ohio law, it should be recognized. And void marriages are those that are specifically against the statute. 3101.01 states that males not less than 18 years of age can marry, females not less than 16 years of age, cousins closer than second cousins, people already married to other people. Those are the void marriages. Other than that, all other marriages are voidable. And there's other case laws such as Dodgerel and Cicchini where people tried to get married, the person that performed the marriage in one case wasn't licensed to perform the marriage, in another case the person performed the marriage outside the jurisdiction where they're authorized to provide the marriages, and courts have upheld those marriages as valid marriages. That is the difference between a void marriage and a voidable marriage. Voidable marriage is still valid when it is entered into, and remains valid until either party secures a court order dissolving the marital relationship. Void marriages are void ab initio, it's as if they never happened. Now, counsel for the appellant is wrong about the testimony of the experts in this case. There were two experts that testified regarding South African law, and the trial judge went through and analyzed the various acts and case law, and their law is similar to ours. They have statutes and they have case law, and the trial court cited all the different types of recognition that Muslim marriages have. There's nothing in our case law that talks about validity. There's no cases that say it's a valid or invalid marriage. That is not the law in the state of Ohio. What our case law deals with is void and voidable marriages.
What did the experts in your review of the case say about whether or not this was a marriage under South African law?
They both agree. Truthfully, they both agree. Now, there are
Well,
various...
that it was?
They agree that the Muslim marriage has legal significance under various acts and under case law. And specifically, Mr. Abbas, who was the appellant's expert, testified on page 44, after I went through a bunch of the different acts where this marriage is recognized. He was asked, "You would agree, sir, that Muslim marriages do have legal significance in South Africa?" Answer, yes. They are not the same as civil marriage. The question, they are not the same as civil marriage, but they are valid marriages in South Africa. Answer, to a degree, yes. Now that's the appellant's expert. Now, one of the most ironic things about the law in South Africa is that they recognize in something called the Children's Act that civil marriages, religious marriages and customary marriages, which is like the Aboriginal type of people that used to live there, those people that are married under all three of those types of marriages have parental rights and responsibilities equal to the spouses. So ironically, in Ohio, if you're not married to, if the father's not married to the mother, under our statutes, the father doesn't have parental rights until those are established by a court. So in South Africa, that's not the case. So if the parties were litigating child custody issues in South Africa, mom would not have been able to leave the country and claim that she had sole parental rights, because under the Children's Act in South Africa, my client would have equal parental rights. But what happened was, mom found out that this statute existed in Ohio and used it, and has been using it, to stay out of the country with the child. So it's very ironic that that's what's going on here, that in fact, my client would have more parental rights under the Children's Act in South Africa under his Muslim marriage. But there are a number of other acts and case law that support parental rights and responsibilities, and rights of intestate succession, rights to claim support, all under South African law with a Muslim marriage. So one of the cases that was testified to by both experts, but especially the Pelleas expert, she testified that the Rose case, which was recently decided, gives the court subject matter jurisdiction to actually grant a divorce. So not only do spouses of Muslim marriage have the right to inherit, the right to maintenance, which is like support, the right to have survivor benefits under a pension, but now under this Rose case, which was cited and talked about by both experts, they have the right to get a divorce. Whether or not the divorce, though, can be granted in South Africa, that's really not the question. The question is this marriage void because it's against public policy or against a statute in South Africa? And there's nothing that the appellant has cited which says it's void, and they can't, because it's recognized for all these various purposes in South Africa. And under our laws, we are supposed to sustain marriages whether they're not incestuous, polygamous, shocking to good morals, unalterably opposed to a well-defined public policy, or prohibited by law. That's the Mazzolini case. And that's been in effect since 1958. It's a Supreme Court case. That's the law. We're supposed to encourage marriage, recognize marriage. So in this situation, the parties were forthright with our federal government when Waheeda, Mullaji, the appellant, came to visit her husband on 2 occasions. She had H-4 visas granted by our federal government based on her marital status. Then she applied for permanent residency, again, based on her marital status. And when there was a question by the Customs and Immigration Service about their marriage, what did they do? They didn't say, oh, we had a civil marriage. No, they produced a letter from the Muslim Council in South Africa that says, and it's an exhibit in this case, the parties were married by Muslim rites on this day in front of these witnesses. That's what they produced to our federal government, and our federal government said, okay, you're married, we're going to grant permanent residency. So the appellant now has permanent residency in the United States of America. She is not she's not like living in South Africa, and therefore getting to the issue of whether this is a final appeal order, somehow can't come and defend this case. And I'll just touch on that issue.
Tell me about the Muslim Judicial Council. Is that a branch of the judiciary out in
No,
South Africa?
it's a religious body. It's a religious body. It's nothing to do with the civil law or the civil government in South Africa. It's a religious body. Let me just touch on that final appeal order issue, because in this Hugeman case, which is kind of an anomaly, truthfully, first of all, it was a personal jurisdiction issue because there was a bunch of defendants from out of the country. And they said, well, this is going to be very taxing on these out of country defendants to have to litigate this matter. And so, to make them go through all this litigation would be very expensive, so we're going to say that we have a final order to review. And that's kind of contrary to all the other case law, which says, well, finances really aren't an issue, and you should be looking at that in determining whether you have a final order. And in fact, the Dave case, which is also a domestic relations case, says the opposite, in that there is no final order, and the parties have a meaningful right to appeal after the case is over. So it asks this court to look at that case, because it is contrary to the Human case. And there's no substantial right that was affected in this case. Really, it's an interim order. And the court found that there is a marriage, and then nothing else has happened. There hasn't been any orders issued to allocate parental rights or divide property. The matter is still pending. So we do not believe it was a final order. So once the appellant did come here, I think it is relevant that they filed tax returns together as married couples. They bought real estate as a married couple. She was on health insurance as a married couple. Their whole life together, after they married, they held themselves out as a married couple. And I'm not saying that because I'm trying to create some type of common law marriage. I'm saying that because our system in Ohio, our laws are to recognize marriages. It's preferred under the law, and that's been the law for so long. And say that these parties aren't married is not only contrary to South African law, because this type of marriage is recognized in South Africa, it's also contrary to our laws. I would just want to touch on the second cause or error alleged, something about not having given notice. There was absolutely notice given that we would be relying on foreign law. It was given in the supplemental brief in opposition to the motion to dismiss, so we have it in writing. Furthermore, the whole issue of relying on foreign law was talked about with the court. They set up Skype for the witness. Everybody knew we were going to be presenting expert testimony on foreign law. And I would just say to you that it's incumbent on the appellant in this case to show that the trial court erred when she found that the marriage was not void. There should be some deference given to the trial judge here. She heard expert testimony. This wasn't just submitted on briefs. There was a whole trial. She heard experts on South African law testify about all the rights that spouses in a Muslim marriage have.
You're working right into my question. Do you want to discuss standard of review? It's not often we have a competing argument about it, but this happens to be one of those cases.
Yeah, I think that there was factual findings here, and therefore I think that there should be some deference. I mean, there's no question that the court has subject matter jurisdiction to grant a legal separation. I don't think that's a question. The question is this a de novo review, or do we give the trial judge deference and do this on a abuse of discretion standard, this review? And I would submit that because there were facts that the trial judge had to learn, she had to hear from the experts. She had to weigh the credibility of the two experts, and I think that's a crucial part of her findings, although they were actually very similar in their testimony about all the rights that parents of children have under South African law that are married by Muslim rights. But the court has to still weigh, when it came down to it, she had to weigh the credibility of those experts. So I think the court should give some deference to what the trial judge did. And I don't think it's immaterial that the court, kind of commented. I suppose it's not strictly legal as to it, not strictly like on point, but she did comment that what happened here is that the parties got married in South Africa. My client was living here, working here, went to South Africa to get married. Mom arranged the whole wedding.
Are you
she's-
getting to that reprehensible part?
Yeah.
You know it doesn't have any play with
And you also know
that.
that you're out of time.
Okay. Well, I would just say that I think that the court should be given some deference. And if she did put that in, I understand it's not strictly what this court should rely on when deciding this case. I think most importantly, she went through all the evidence that she heard about the rights that parties married by Muslim rights marriages have in South Africa, and she found that this marriage is not void.
Okay,
And so I would ask this court to affirm the trial court's decision.
thank you.
Thank you.
We have about 2 minutes remaining.
I'd like to answer the first question, or the last question about jurisdiction, and the issue of what's the standard of review. I believe this court's already addressed that. In the Bolenbacher versus Wayne County Board of Commissioners, this court said that on a motion to dismiss filed pursuant to 12B1 that challenges a trial court's exercise of subject matter jurisdiction, the review is de novo. It is not abuse of discretion. It is a de novo review by this court, and this court has already ruled on that issue, I believe. I would like to address a couple of things that counsel has mentioned in his argument. The first thing is counsel says that both experts agree that the parties had a civil marriage. When you read the transcript, you will find on page 88 that the appellee's expert, Ms. Julin, said that on line 3, referring to a ceremonial marriage, it would be a valid marriage for certain purposes, support, parentage. And then she says, it would not, however, constitute a civil marriage. That's the key issue. Their own expert said, yes, there are some exceptions if you want to seek support, etc. It is not a valid marriage.
I thought you started this saying the issue is valid
I agree.
versus void, so.
I don't think the issue is void. I think the issue is whether the parties have a valid civil marriage under the law of the country of South Africa.
Civil? Who's putting in the word civil?
The experts.
I guess what I'm asking is
Okay.
that the standard
Yes.
we should be looking at?
And is the word civil defined the same in the United States as it is in South Africa?
Well, that's part of the whole issue.
Okay.
I don't disagree.
And we'll look into that because you're out of time.
Thank you very
Thank
much.
you. We will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and that of the Supreme Court. Thank you for your presentation today.
Thank you.